After 6 months of back and forth at the courts, Bahamian nationals Kelvin Leach and Ron Knowles have been freed of charges for failing to declare in excess of 10,000 Belize dollars before departing the PGIA. That was the decision made by Senior Magistrate Sharon Fraser today following a no-case submission by attorney Godfrey Smith on behalf of his clients.
In truth, it wasn't a complex decision in my view, nor a complex case, although it was a drawn-out case with over 12 witnesses. But at the end of the day, as the judge rightly pointed out, the whole case turned on whether the gentlemen were guilty of failing to declare sums in excess of $10,000. The prosecution's own witnesses said that you were deemed to commit the offense after you've cleared all the official checkpoints, namely Airports Authority counter and immigration counter. If after that you not declare, then you've committed the offense. And this wasn't the case, so as the judge rightly pointed out, it was entirely premature.
So that's the end of the FIU case against Leach and Knowles. According to Smith, he will now apply for the monies, accounts, files and documents seized by the FIU to be returned to his clients.
The real story here, this was a foregone conclusion, the result of this case. The real story here is that the state has acted in an extremely oppressive manner in relation to these people. You will recall that around September 9th or thereabouts of last year, police swooped down on these gentlemen's office, seized all their documents, froze all their accounts, and eventually detained them in prison. What has happened since is that, first of all, the courts have found that their detention was completely without authority, so that they had been unlawfully remanded and detained at Hattieville prison. Secondly, that their monies were unconstitutionally and unlawfully frozen. Thirdly, that their documents and all the documents for their clients were unlawfully seized and had to be returned. I say that to say this, that damages loom very large in this case. Because of all of this, these gentlemen's business have been shut down completely, and the court has found unlawfully and wrongly so.
Their detention came as a result of information that the U.S. government wanted them in connection with $1 billion securities fraud allegation. As to the extradition request from the U.S. for the Bahamian nationals, Attorney Smith says that he believes that the local authorities were acting based on instructions from agents of the United States government.
Having gotten over now this final stage, the extradition request has been made and is pending before the court. But this is what I have to say. That extradition request is based on information put together unlawfully, illegally, after they had illegally seized the documents and all the computers, had it for, I can't remember, in excess of 2 or 3 months, 2 months, and used that information to create an extradition request, to form the basis of an extradition request. That might be permissible in the United States, from which this entire operation is being directed. It is not permissible under the common law system. You cannot use unlawfully, illegally obtained evidence to form the basis of charges you're going to bring against anybody for extradition. So we intend to attack this at the very root, at the very first opportunity. That is my view. From day one, they were acting under the direction of agents of the United States government.
Sir,
the problem with that is that, as I've said on a previous occasion, when the illegalities are found to have been committed by the court and damages have to be paid, it is not the United States government that will be paying it. It's the taxpayers of Belize. So the state has an obligation before it rushes to do the bidding of the United States government to make sure that it checks its case properly before saddling taxpayers with hundreds of thousands, if not millions of dollars in damages.
Dwayne Moody for News 5.